G'day everyone, and welcome to the second video for week 5 of our legal ethics course. This week we've started our journey of exploration into the ethical nature of the lawyer-client relationship. In the first video we explored some of the general dimensions of that relationship, and in this second video we start getting more specific. We're going to talk about the duty to provide the client with clear and timely advice, because ultimately, as lawyers, that's what we do. Someone comes to us with a problem and they ask for advice about that problem. We provide that advice. Sounds simple, right? As ever, the place for us to begin is the solicitor's conduct rules. Rule 7.1 says a solicitor must provide clear and timely advice to assist a client to understand the relevant legal issues and to make informed choices about action to be taken during the course of a matter consistent with the terms of the engagement. There's a bit to unpack in this rule. The first thing is that before you can help the client to understand the law, you have to understand the client. The first step in providing good advice is understand the problem and understand what the client is asking you to tell them about. Now, in a way, law school has started to prepare you for this. Every time that you've ever done a problem question, whether for assignments or exams or even just tute questions, every time that you've ever done a problem question, you have been presented with a set of facts from which you can identify a legal issue or more than one, and you have been asked to advise the client. The thing is, those problem questions are written by lecturers who understand the law better than you do. And those lecturers are attempting to guide you to identify and resolve the legal issue. Real clients aren't like that. They walk into your office, they sit down, they may be upset, they may be angry, and if you're lucky, they just start to talk. If you're unlucky, they sit there in silence and you'll need to ask 100 questions. Either way, at the end of 20 or 30 minutes, you will have pages of stuff, and most of it will be irrelevant. The things that upset or engage the clients are not always, indeed they're seldom, the things that you most need to know in order to resolve their legal problem. So the first step in developing timely advice is to listen to your client. Let them say what they feel they have to say. Let them vent and get out all the stuff they really need you to hear. Take notes of all of it, but then guide the client back to the issues that really are issues. Get from them the information that you really need to get. There's an art to this. If you're doing commercial law and your client litigates all the time, it'll be relatively easy. If your client is a young person who has just been arrested and spent their first night in a watch house, it's going to be a lot tougher. Clients will vary in their knowledge of spoken English, their level of intelligence, their background knowledge of the law, their state of mental health. All of these things will affect how hard it is to obtain from your client the facts that you need in order to provide them with the advice that they need. So let's say that you've obtained enough information from the client that you now feel confident that you understand the nature of their concern. The next step is that you must be diligent in providing them with advice. Now this sounds pretty obvious, right? But it's actually very easy to let this slip. As you become more and more familiar with an area of law, you might start to have a tendency to just assume that you understand the law in that area. So you might not actually pull open the statutory provision each and every time, or you might be so used to citing a certain case that you suddenly realise it's a full year since you last actually read the case. Or you might send the same sorts of letters so often that you just start using a pro forma without adjusting it properly to suit the circumstances of each individual client. It's really important to give every client your best efforts. You will make mistakes, of course you will, but you should be able to look every client in the eye and say that you gave them your best effort. And that includes clients that you don't like, clients who are too demanding, or who give you a hard time, or who make you chase fees, or clients who you feel are lying to you. Doesn't matter. You have a duty to give them the best advice you can which means you have a duty to be diligent in preparing that advice. However, what we mean by clear and timely advice changes depending on the client. Advice which would be suitable and helpful for a sophisticated business client might be completely inappropriate for a client with little understanding of the law. Your advice is useless unless your client can understand the advice and apply it to their problem. There is a genuine art to working out exactly what register of language your client needs and providing them with advice in that register. In a case called EVBJ Proprietary Limited against Greenwood, an accountant gave some complicated tax advice to a solicitor for the solicitor's client. However, the accountant knew that the solicitor was not knowledgeable about taxation matters, but the accountant still pitched the advice at a level which seems to have gone way over the solicitor's head. The court found that essentially giving someone advice they can't understand is pretty much the same as not giving them advice at all. Next, you need to understand that you owe your client your best advice, even when you know that advice is going to be unwelcome. Sometimes you're going to have to advise a client that whatever they're after is profoundly unlikely or even impossible. You will get clients who are asking for outrageous remedies, or clients who struggle to believe that they're not entitled to a remedy at all. They might struggle to see this, but you're actually helping them if you explain to them that they're in the wrong, and you explain why, and you help them to see it. In the best case scenario, you can help them to deal with their anger and sense of outrage. But in any case, by being straight with them, you can prevent them from spending a heap of money they probably don't have on legal action which is doomed from the outset. Next, I'm going to say something that will probably be familiar to some of you from your assignment feedback. Your client is coming to you for advice. You have to actually provide advice, not just general wordage. No client is ever going to sit down in your office and say, I think I'd like you to write me a general essay which talks a bit about repudiation of contract. When they come to you with a problem, they don't want a general discourse that happens to touch on that problem. So what should you be providing? A good advice actually more or less follows that good old IRAC pattern that you've had drummed into you since first year. You start by identifying the legal issues that arise from the facts that the client is presenting. You then outline the relevant law for the client, pitching your language at a level that you believe is appropriate for this specific client. The heart of your advice then comes in application. You should provide your client with options, different ways they can approach their legal problem. There are almost always options. The only time that I ever had a client where I felt there were no options was a client who was being sought by police. The only option that I put to him was to surrender to police. But in 99.9% of cases, you'll be able to give your client options. Options are a two-edged sword though. On the one hand, when a client has options, they're still at least somewhat in control of their own destiny. On the other hand, as you will know if you've ever tried to compare phone plans, private health insurance, or electricity providers, sometimes too many options just results in confusion. So for each option, you need to provide your client information about the risks associated with each option, the likely outcomes to be achieved, the costs associated with each option, the time frames, and then at the end, you make a recommendation and explain why that is your recommended option. That way, after reading your advice, the client has a range of options to choose from, but you have also pointed them in what you believe to be the best direction. Finally, I want to speak for a few seconds about the situation where you're providing advice which the client is clearly not going to follow. This often happens if you're giving them advice that they don't like. So they've been making threats to sue somebody, they've come to see you, you've taken a look at their circumstances, and you've told them they don't have a single leg to stand on. If your instincts tell you that the client is going to go right ahead anyway, make sure you protect yourself and your firm by putting your advice in writing And if the client tells you outright that they plan on taking some course of action which you think is undesirable, send them more advice explaining that you do not recommend whatever it is they're about to do. You see, this is exactly the client who, when it all inevitably does go pear-shaped, they will want to share the pain by blaming you. Give your advice in writing. Happily, for the first couple of years at least, your supervisors will almost certainly want to see your advice before it goes out, and you'll probably be prohibited from giving oral advice. So that's the end of video 2. We're looking this week at duty to the client, and this duty relates to the duty to give your best advice. This means listening to the client and genuinely identifying the problem. It means diligently working to confirm the relevant law and providing the client with clear advice, including options, the pros and cons of those options, and a firm recommendation for which option they should follow. In the third and final video this week, we're going to look at the duty to act within instructions. This is crucial to understanding the lawyer-client relationship. We might be the ones with the legal knowledge, but the client is the one who's ultimately in charge. See you in video 3.